Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Oh, for Trump's sake. Dati mihi Anglican, please.
Is that correct?
Literally not true. I didn't ask you to interrupt me.
Good morning. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's been one of it's been one of those mornings already. But we're okay. Fine. We're good. Okay, go. Let's see. I think we're good. We're just troubleshooting the last little problem. Refresh on my end. Go live. Boom. All right. Okay. Good morning. What a day. Oh my goodness. Yesterday was wild. We will be, for those that are maybe new here, we've got a few new people the last couple days. Last night specifically. Because apparently I'm the guy. I'm apparently the guy that cracked a case, I guess. I was not Sherlock Holmes. Okay, I was not like even Matlock or anything like that. I just said what everyone else was thinking, and I said it out loud. And I said it. This was on the other case we were following on the Georgia via Melody Ferris, and I just said it out loud. And the only reason it made a difference because I said it was because Martha Jane, one of the people who had been mentioned in the trial, was watching my stream when I said it, and she knew I was right, and she made a call and said to the police and said, my conscience has been eating me up. I need to tell you. You know, when I heard my name, on TV, the guy with the headphones said my name and said that's where the gun came from. I had to call and say, yeah, my gun's missing. Crazy. We will catch up with that case when this one's done. But all right. We are We're live. Hang on. Hang on 1 second.
If they didn't, I would lose my mind.
I think I've got the wrong link.
Somebody just sent me a video of roaches fighting. I don't know who won.
There we go. Now it's live. Okay, our feed from court is finally up and working properly. I've got a couple do a couple things.
Shame on you, sir.
First of all, we're going to be jumping to court in just a minute. We have our feed up and working. It looks blurry because the camera is focused on the pull string, not on the seal and back. So that's why this screen looks a little blurry. We'll get that fixed when the camera fixes it. I have to say a huge shout out to Trial TV Live, who is down in court. They are down. Chris is down there outside the courthouse at the media pedestal, running our equipment to bring us this live feed from court. Chris, thank you very much. Aaron also back at headquarters running the live stream, a clean feed without commentary like mine. If you want to see it without me, it won't hurt my feelings. Without my commentary, you can watch that on Trial TV Live. Thank you, Chris and Aaron. It's a great partnership. I'm looking forward to doing much more with them in the future. A few things we have to cover. First of all, internet ownership. I'll do that after the song. Let's sing Happy Birthday because we've got just a couple minutes before court starts. We're going to sing to Vivian Anderson, Ann Twigs, and Crunchy Frog. And yes, we sing Happy Birthday to everyone who has a birthday every day. Almost every day we sing. I think every day we've sung Happy Birthday almost for a year. It's been crazy. It's been crazy. So join with me if you will. Warm up with me if you will. La 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 la. There we go. All right, Vivian Anderson, and we're going to do Vivian, Ann, Twigs, and Crunchy Frog, if that works. La, 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 la. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Vivian, Ann, Twigs, and Crunchy Frog. Happy birthday to you. Vivian, Ann, Twigs, and Crunchy Frog, of all the days, today is yours. Happy birthday. I realize there are a million places you could be and a million people you could spend it with, but you've chosen to be here with us. The privilege, the pleasure, the honor is ours. Hopefully we can return some of that joy to you today by making your day a little more specialer. Yes, a little more specialer. And the best way to start out by doing that is getting free pancakes at Denny's, IHOP, Village Inn, Waffle House, wherever they sell pancakes. I'm not sure if McDonald's has bought into the whole free pancakes on your birthday thing, but it's worth a shot. It is, after all, your birthday. So give it a shot. Thank you very much for being here. Thanks for sharing your special day with us. I think it's the best way to start any day by singing Happy Birthday. It helps the people who have a birthday because it makes their day wonderful. And it helps us because we feel good making your day wonderful. So it's a win-win. I'm glad everyone across the nation and around the world joined in with us singing today. I'm still hearing echoes from outside my house from people who are singing happy birthday. We'll let the music play for just a minute while we do a couple little messages. First of all, Judy Freese, love this community. Thank you all for all you do. Ari and mods. We have amazing mods here. Judges coming in. Super excited for today, says Lilith. Happy to be here for you, for this, guys. Thank you, Lilith. Danny Austin gifted a membership. Thank you, Danny. Tinez, 827, member for 16 months. Says, question, RA, actor, you commissioned to play you, the man down in the corner. Who would you like to make? Well, comments with earphones on. When this is made for TV movie. Who's going to be my actor? Who's going to, oh man. Do I have if I have a doppelganger, I feel sorry for them. That's all I can say. Jamie L., member for 18 months. Thank you very much. Last verse here. Big drum solo finish, so get your air drumsticks ready. Thank you, Jamie L., for 18 months. Guy in the corner. Here we go. Ready? It was beautiful. Great finish. Thank you for joining me on the Happy Birthday song. As we now go back to Sarah Boone in court. Let's see. We have... switch views here. Turn that one off. Just getting everything ready. Has to be Tom Cruise. Could be Tom Cruise. I could not be Tom Cruise. Tom Cruise might be able to put on enough masks to look like me. Today is going to be so good. Kathy, what we're expecting today is, let's see, is the state all the way done with Detective Coespel? Because if they are, we're going straight to cross-examination, and then the state will rest. I think the state is done there. When defense takes over, first witness we expect out of the gate is going to be Sarah Boone, her testimony. Whether she testifies in the narrative, where lawyers, as I was on with Ian Runkle last night, and thank you, Ian, that was awesome. Thanks for the invite. Love to spend a little bit with you last night. Erica owns the internet. Sorry, I forgot this. First person in chat every day wins the internet. Erica, 843, that was you. I had some issues where YouTube, for some reason, only wanted to let my mods chat, which would be great. I mean, I love my mods, but we like to hear you guys too. So I fixed that and let you in. Erica was the first one through the door after I fixed it. Congratulations. The internet is all yours. As punishment and prize, we're sentencing you to maintain everything IP-related worldwide for everyone. So your phone's going to be a little bit busy, but you can do it also also, you can head over to the shopping page on our YouTube channel. And if you scroll through, you'll find that there is a internet ownership certificate, which you can download and fill in the blank. It's already pre-signed. It will be just to commemorate this occasion where you, in fact, did own the internet. And it's suitable for framing, hang it up in your office, behind your desk on the credenza, or use it as a cover sheet for your resume. Either way works. But thank you, Erica. Appreciate you doing this great service for all of us. All right. Ian is wonderful. I met Ian, obviously. I think I met Ian through Rob. And I got to help out a little bit with the last time he did his big fundraiser thing. We auctioned off a hoodie, a signed hoodie, which was really cool. First of all, I'm not sure why anyone would want me to sign and ruin a perfectly good hoodie, but they did, and there was generous donations, and love to help a good cause. Look forward to helping him again here in a month or two as we do that same thing. All right, where was I? Sarah Boone, first testimony today. That's going to be incredible. If the lawyer says we'd like her to testify in the narrative, which if you guys watch let's say like the Robert Tellis trial, the gentleman who was missing some hair, he was bald, the politician sort of guy out of Las Vegas that was accused of murder, the shiny orange coat and the big hat, straw hat and everything, all caught on video. If you watch that, he testified in the narrative. What it means generally when somebody does that is that the lawyer thinks they're going to lie. And a lawyer has a duty to correct the court. They can't elicit false testimony from a witness. And so asking the questions that will make the witness lie can get the lawyer in trouble with their bar license. So sometimes when a lawyer thinks they're going to lie, they might say we'd like them to testify in the narrative, where they sort of just free spool. And it ends up being more rambling usually and much more in depth than is needed in areas that shouldn't be, and a lot of objections. But either way, either he guides her carefully through the questions or they testify in the narrative. Sarah has to testify. And her story has to be told, and the story has to be different from what she said before. Because what she said before does not qualify her for the defense she is claiming. So she needs to bring up things that would show that there was this history that would allow her to claim the battered spouse syndrome situation. So we get another story from Sarah. Which one you believe, that's up to the jury. Obviously, the prosecution, once she tells this last story, will remind her of the other stories she told and how different they are, and the jury will get to hear that. So, all right, am I forgetting something? Headphones, pants. I'm good. I think I'm good. Erica, adding internet ownership to my LinkedIn now. You should, and put me down as a reference if you don't really care about the job. I mean, I do take prank calls, and sometimes it's hard to distinguish between a prank call and a legitimate call. I have been known to answer what I thought was a prank call using a funny voice, a funny high squeaky voice, which I will not mimic on this channel, which I can usually carry on for a short while without causing pain to my throat, only to find out that, in fact, the person who was calling me was a very important call for me personally, and one I had been waiting for a long time. And I had to continue using that voice throughout the call so as not to make them think that, they could think I was weird and had a strange voice. That would be better than me, oh, sorry, I was pretending to be goofy when I answered the phone. Oh my goodness, that was so embarrassing. It was so bad. Yeah, little regrets. November 3rd for Ian's auction. What should we contribute for the auction? Should we make some specific, like a specific merch item that we contribute? Or should we go with something we already have? Is there cross-examination after us being heard? Yes, Amy. This is the thing. On direct, you shouldn't be able to lead. Some courts allow a little more leeway than they should, but they should not be allowed to lead on direct. And when defense has the case, their witness, they are on direct, and the prosecution becomes on cross. Cross is allowed to lead. they can really get down and direct a question where they want it to go. And they will be able to do that with Sarah. And that's going to be brutal. I think it will be brutal. A set of mugs, one of each color. Speaking of Sarah, Sarah is here. This bailiff has been her, usher. I guess ushering her to her seat every day so far in court. We heard yesterday there was a lady in the back that came into court and yelled, "Is this the Sarah Boone trial or something?" And then when the bailiff ushered Sarah Boone in, she yelled something to the effect of, "You should be fired," possibly at the bailiff, because it's not like this is Sarah Boone's job. We're not sure. There might have been a mental issue at play. The judge, after consulting with both the prosecution and defense, they did decide that they would like to proceed with court without her present, and they invited her to watch online. But we haven't heard of any such outbreaks today. I was thinking we need to make some sort of merchandise commemorating the occasion in the Georgia trial that says, I watch YouTube and solve crimes or something like that. I'm not sure how to help. Give me some ideas. What would be a good merchandise item that you guys would want to wear or own? Georgia, we'll go back to the Georgia trial. If I can recap very quickly. We were watching, I think, day 8, part 2, 2 hours, 20 minutes into it. Rusty was on the stand, and we were hearing testimony about his stepmom, I believe, who was Martha Jane, and we heard about firearms and stuff, and I said, I think I see where they're going. Melody stole the gun from Martha Jane. Well, Martha Jane was watching our live stream, and she heard me say that it was her gun that was stolen, and she knew that her gun had gone missing, along with a couple other items when did I say Sarah? No, I'm mixing up. Melody had been over at her house in Stain, and things had gone missing from Martha Jane's house, and she knew that things had gone missing, including that .38 special, and she had never told the police. And they had never asked. They never asked about her guns either. And when I called her out sort of on the live stream, she knew her conscience got the best of her. Even she's 84 years old and not doing well. She said, I can't take this with me to the grave. Made the phone call to the detective and said, there's something you need to know. I was watching court TV, and that man down in the corner with the headphones, he said that Melody stole the gun from Martha Jane's house, and my gun's missing. So we made it sort of into court. I'm not on court TV, but she thought she was watching court TV. Ended up on my channel. It happens a lot. The judge did that in Zachariah Anderson's case. Watched our channel, but so she's going to be testifying in court on Thursday in the Georgia trial, and we think we're going to be done with this trial by then, including the verdict. So we'll be catching up on the Georgia trial here. Lucky 13 Boone merch sandals that look like you're barefoot. Barefoot clear sandals. Kayla Newell says, I was on Replay Crew this AM, and RA, you're famous. Kayla, it's cool. It's cool. It's always Court TV, no matter what channel it is. Court TV has a good name. Whoever came up with that name, it's like Kleenex. It's like you don't go to the store and buy tissue. You go to the store and you buy Kleenex, no matter what brand it is. Court TV is like that. And good job, Court TV, for establishing that brand. The man in the corner with the headphones. Creative B, thank you. First of all, I'm glad you can chat, Debbie. I saw your text the other night where you were having trouble. YouTube has been giving a lot of people trouble recently. Glad you're back. Debbie is fantastic. She's the one that designed this. I always pick the wrong one. Over my shoulder, this YouTube plaque. She made that one for me, and the other one, which I still have not hung, Debbie, and I'm sorry about that. If you ever need a little custom plaque made, the Creative Bee on Etsy is fantastic. She made them for our mods when I sent out some little thank yous to them as well. Does a wonderful job. Jinx, I need to talk to you. Because I'm terrible at email. And it's been just a busy day. I want to talk to you about, I know you said you got some merch ideas, and I'm going to list my restrictions because I'm still a very small streamer. And I hate to break it to you, but it's not all easy money all day long doing this. There are a ton of bills. I mean, we're paying thousands of dollars for equipment to get feeds, and it's rough. But so I can't order a billion things of merchandise. Still no audio yet from court. We're just waiting for that. Looks like they're discussing some pre-trial stuff, possibly scheduling. Bean Brains here from Runkles. Welcome. Ian is amazing. He's the Gandalf of LawTube. Okay.
Two of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The third incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the fourth and fifth incident. I was told that on Tuesday, day 7 of trial.
Okay, we had terrible audio there.
Second discovery issue
we're getting it fixed. That was awful. Sorry about
Friday,
that.
I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health records.
On 10/18, October 18th. That would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced into court, so I can confirm those things ahead of time and not in court. And then the third thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down, and I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's one that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know, and I think that has to do with a body cam where it comes to, and I believe it's Mr. Torres's mother. I can't quite be for sure, but she's been asking questions and all, and I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that to let the state know. I just don't really know the relevance. It could come in at a different point and become relevant. But as to the other two, I think we were on page with. I had been out to the jail that day. It was late. Then I asked Mr. Beck to do the other two redactions, but I hadn't had the opportunity to talk to him about that since, so that's where we are.
So is the third incident that the state has identified for which there's seemingly no responses to redaction, is that the body-worn camera purportedly between law enforcement and Mr. Torres's mother?
That's what I believe it to be.
Mr. J?
We're just not on the same page. On that third incident, which I believe was June 15th of 2019, the state only indicated to them that we were intending to introduce one video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID, and I don't know that as a legally recognized objection. So I'm confused. I'm not sure. I'm just trying to make sure we're all on the same page. We understand which file the state wants to use regarding that third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree. There's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out. We're going to cut that out. That cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we could be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
All right, addressing the third incident is the specific portions of the June 15, 2019 incident, seemingly the body-worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And Judge, it's a lot, so if I could have one more to isolate which incident it is. That's not the one. My understanding is the state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So we can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates at 9:40 to 9:43, there's a redact request with paren previous arrest. The state agrees to that. We heard her quickly say that at 9:43, and we will get that taken care of. Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19055572, and it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_video_2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files, it was just 1 file. And then again, with the other 2...
I don't want to address 4 and 5 yet. Okay. It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
Tweet, it's for the record.
No redaction.
Just typed out on the record.
With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon_flex_2_video_2019-08-28-2024. And then at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file which has pictures taken by law enforcement of her injuries. I don't see anything else in there. One picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28, 2019, what say the defense?
What say you?
John, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to the investigating officer that they may want to redact. We're not asking any to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then...
So are there any redaction requests with regard to that particular file?
No, Your Honor.
Okay. I'm just keeping notes. Give me a moment, y'all.
Thank you, Elijah. The judge is great with notes. When he says that Sarah's wearing civilian clothes, it is for the record, because the record is a typewritten copy. It's not a video. So that anyone who goes back and reviews the record will understand what happened. He's very meticulous about that. I like that.
As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Okay.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and then resent it this morning, was photographs of the defendant taken at that time at their request. Shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Oh, strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redactions, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres. One seems to focus on Ms. Boone. And there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower or master bath. I don't know. And so some of that's redundant, but there are actually 2 separate videos pursuant to the fifth.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's one, the one that I listed filing for that important court.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of... as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Okay. Mr. Beck, the specific file number was identified. So just to confirm, no redactions?
No.
Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state, to which the defense has no redactions. The August 28th, 2019 incident, for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week, we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday. How that list was culled down and the additional pages that the state was seeking, and then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted extension out of the rule of completeness. I believe we're...
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in. Those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure if it exists, Your Honor. That's what we're saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages just to confirm it. Lastly, with regard to hospital records of the victim, I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, George Torres.
That's my understanding.
We need to do that, Judge. We've yet to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I can be here Thursday, and I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Coral Gables.
Did either Doctors Brandon or Harper rely on those medical records?
No.
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering.
I went up there.
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of George Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state about everything that she relied upon, and she did indicate that. Are we going to use or attempt to introduce those records? We'll pare it down if we are.
Okay, you've got till 5 p.m. today to advise the state as to what of those culled down records you're going to be utilizing. So they have the opportunity to review those in advance of Dr. Harper testifying.
And I apologize to Madam Court Reporter for speaking on top of each other. Dr. Brandon is testifying as a subject matter expert who does not have specific familiarity with this case. And so there are no medical records or any other records that he has relied upon other than his knowledge and expertise.
Okay. All right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay. All right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to discuss it, and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that, and we can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right. Anything else, Mr. J?
I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. So excuse me?
I'm not.
Can we approach the bench?
Sure. Come on up, y'all.
Come on up, y'all. The judge issues the invite. They're fighting over little details about how court's going. It looks like they're talking about as late as Thursday having one expert witness testify. We'll see exactly how long it takes. I think this court's going to go faster than they expect. But if the expert's not available, then it's not available. So I love courtesy copy. I'm a carbon copy years old. Carbon copies were great. What was I remember going to school, my teacher in elementary school, they had that like the roller copy that you'd turn and it would make copies. I think it had like a yellow paper on it. It was like a printer, but you like turn it and it's a hand crank copy machine, fully manual, mimeograph. Yeah, that's how old I am. Sarah is back. She does. I haven't seen, we didn't see a lot of her, but she doesn't look nearly as cheerful as she was yesterday, like giddy cheerful. Maybe the fact that she has to get up and testify today and face cross-examination has got her down a bit. Crunchy Frog, you're absolutely correct. The defense is extremely short-handed on this one. They came in at the last minute. Wasn't their fault. I mean, I would say, yes, it is their fault. They chose to come on. They volunteered to take this case. But they came in knowing the judge will not give them any extra time, even though they just barely picked up the case. And to the judge's credit, he stuck by it. He hasn't. So... we could count non-intentionals. We got up to got up to 57 non-intentionals in the video alone. So we might continue the non-intentional counter while she's on the stand. And then anytime she says, I didn't mean to, or was not intentional, or some variant of that, or if someone else says it in conversation to her, we'll count that as well. So, but currently we're counting the bless yous from the judge mostly. We're up to 14 for this trial. We should also do it's not fair. Not intentional and not fair. We didn't count not fair yesterday. The not fairs in the interrogation interview really came about at the tail end. When they started saying, well, this is what it is, and you're going to be charged. That's when she said, it's not fair. It's not fair. It's not fair. The girl with the animals, thank you for gifting a membership. Thank you very much. Patricia, you're the lucky winner. Congratulations, you're in green. You have escaped the purgatory that is slow mode. I would remind everybody just during this break, please don't share anything with us right now about the Melody trial. We're super excited to go back and watch that. It's always a challenge when we have two really interesting cases going at the same time. We will return to the Melody trial and get caught up with that as soon as this one is over. We're going to speed trial and catch up. But we don't need to know who's on the stand or when they started testifying or if they're taking a lunch or break or anything like that. So please don't share that here. I have put some keywords in the ban list. So if you try to share it,
I thank you all very much. With regard to that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. Jay shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to proceed, sir?
Yes.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right. Let's go ahead and stand and bring in our panel.
Another absolutely. I'm absolutely happy with my defense team from Sarah Boone. That's been her answer throughout this trial. No hint of dissatisfaction in her voice. I'm not sure what the judge would do if she said no. Mr. Fix-It. I can't help you on that one. I can't spoil it for you. He does ask her that every morning, mostly because she's had so many attorneys that she has not been happy with. Before, one of the last things she brought up with the judge before the jury was seated was her concern that the jury find out about how many attorneys she has burned through. She did not want them to know that she's had 8 prior attorneys. She could care less if they find out she's currently in custody, but she did not want them to know she had 8 prior attorneys. And so far, they don't.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone will be seated. Thank you. Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
I've been pronouncing that detective's name wrong. Thought it was like Cowspell or something. Kepsel. Kepsel. I apologize, detective. My apologies, I should say.
You swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Again, could you state and spell your name for the record?
Yes. My name is Chelsea Kepsel, CHELSEY, KOEPSEL.
All right. Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving. Is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner down there?
Detective Scott Lowen.
And throughout the whole time, you and Detective Lowen worked on this case together. Is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
So that had already been done by the time that you arrived. Is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses. Is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone. Is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it. Is that correct?
Yes, we have.
Okay. And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it. Is that correct?
Yes.
Okay. All right. So, and out there, that's part of talking to witnesses or potential witnesses. Okay. Also, it's your job, too, to identify potential physical evidence in a case.
Yes, it is.
All right. And in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right. And was Miss Melissa Roffengarden, is that how it's pronounced? Pronounce it for me.
Roughgarden.
Roughgarden. Okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but...
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
Yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one. I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically. But that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case, potentially. Is that correct?
Yes.
And some of these items you actually collect with the potential that you might need to have them examined in greater detail. Is that correct?
Yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything to your knowledge sent off for further examination?
I believe so. but if it was, there would be they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
All right. In fact, that was done on her interview date on the, would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of George Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
The focus is a tiny bit off.
Are
on
you
the camera.
aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
Okay. During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
So after the autopsy, you had additional information, is that correct?
Yes, I did.
Okay. Now, there was an interview, well, I don't know if it was an interview. There was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification, and I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy, and then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving. We're going to make next of kin notification. She was very concerned about that. So I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone. Is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone. Is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry. Did she give you permission to take the phone?
Yes.
Okay. Is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time you hadn't applied for any type of search warrant to get or search the phone. Is that correct?
No, it was based off of consent.
Okay. So she had consented to you for you to have her phone.
Yes.
Is that correct? She also provided you the code to get in the phone. Is that correct?
Yes.
So at this point in time, Ms. Boone is cooperating with you. Isn't that correct?
Yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded, and at the time I was willing to give back her phone before going through it, and then once we had gone through it and those videos were found, I felt like this was very different, and it changed my perspective on consent, and I decided at that time that it was best to write a search warrant. So consent couldn't be, basically, like, I knew I was going to take her phone, so consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day, and then it was signed the next day, on the 25th.
So basically what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received. Is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could get a search warrant to go through the phone based off there being evidence, like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
since they had explained to me that they spoke with family members the night prior, so I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay.
Sarah's angry about that.
So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 20th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her or set up this meeting with her. Is that correct?
It's one or the other.
One or the other?
Yes.
Okay. As to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes, it was a summary, yes.
All right. As far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, or they train you that your report should be very much in detail. Is that correct?
Yes.
Okay. Because you might have to refer back to them at a later time. Is that one of the reasons?
He's trying to lay a trap here.
Yes, and to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right. To meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay.
That was the trap. That was the gotcha.
Having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good. You remember telling her that?
That never happened.
Okay.
This is amazing. I'll tell you why. This attorney is doing what Sarah wants right now. This is Sarah's narrative that he's pursuing. It's absurd. It's
Judge,
irrelevant.
if I could have a moment.
Yes, sir, of course.
But Sarah wants to question this. She thinks she was trapped by the investigator. She thinks she was tricked to get there. She thinks she was lied to. And they said I would just be going down to get my phone. And they were going to bring it back to me. And then they said, oh, I'm sick. You have to come down and pick it up. And this is her big gripe. And her lawyers are now her puppets as she's having them pursue this line of questioning.
Ma'am, during this time frame, were you pregnant at that time?
Yes, I was.
Objection to relevance.
All right. Well, anyway, Ms. Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
She did.
25th.
Yes.
That we saw. Okay. Now, ma'am, I'd like to talk to you about some other investigation. On other witnesses that you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay.
Just to be clear, I don't know what the detective told Sarah, but it doesn't matter. It doesn't matter if she was tricked or lied to because cops are allowed to do that. To Sarah, it matters, but it's just not helpful in the case.
As to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Okay, so he lost an opportunity there. There were previous times where the witness had asked and said, I hesitate to answer without looking at my report. He could have had sort of opened the door to that report a little bit sooner. But yes, she has to first have her recollection not clear in order to then have her look at her report to refresh her recollection. He didn't do that first, so proper objection and sustained.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right. I would again object. She hasn't indicated that she needs assistance with her memory.
Approach.
All right. He should have asked another follow-up question and say, do you know if it was on the 27th? Do you have independent recollection? He needs her to say no, or I don't remember, or I need to look at my report. That's all he can do to get it. But also, the part that refreshes her recollection
Objection sustained.
Can just be the part that he's asking the question about. He's not going to be like open the door to everything when he gets her.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you.
She's playing this game and she's good at it.
Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres. Is that correct?
Yes.
And he's the one who told you about the loud noise. Is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but tag Lowen. Something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Okay. Now let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And, ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object as to relevance.
Approach.
This is Sarah's question. This is her complaint. I feel tricked. This was a trick to get me down here. And the lawyer is reading off Sarah's, like Sarah wrote his question list. It's important to Sarah, but it's not important to the court, and it's not illegal. It's not fair all over again. But it's also probably goes to a long way to why Sarah feels that she's absolutely thrilled with her lawyers, because they're doing exactly what she wants, and it will get them nowhere. The police don't have to tell you when they plan to arrest you. It's generally a surprise for almost everybody. Sometimes you'll know. Look, like the Crumbly parents knew there was an arrest warrant for them. They were going to turn themselves in, but then the police still showed up and arrested them early. Cops can and will lie. Yes, I was talking to Ian Munkle last night, and
objection's overruled.
Overruled. He's going to let him go there. That's why he says don't talk to the cops.
So, ma'am, at that time, you did not tell Ms. Boone prior to coming down there that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her.
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney, too, to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up, and you tell her that some things that we need to talk about. Is that correct?
It's specific verbiage. I know I said something along the lines of obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
Sounds like verbatim.
Okay, but prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest. Is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason? Could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
This is something they fought pre-trial. Specifically, the Miranda warning that she read, she didn't read like the last line, which is not part of the Miranda warning. They fought about this back and forth, and the defense basically can't go there. They're going as close as they can to that. And this is once again Sarah's argument. You tricked me. I thought I could leave at any time. And really, you knew all along you were going to arrest me. Yeah, they did. Yeah, they tricked you. Yes, it was strategic. 100%. Does it matter? No. Not in a legal sense. It does not matter. As long as what they did was right, and they did, if they followed the law, you can be tricked. They can be deceptive. And Sarah fell for their trap, and she's mad about it. Her chance to do something was during that Miranda rights. When they asked if, you want to speak to us, yes. And she went ahead. She was informed she could have had a lawyer. That was her time to get one. This detective is when she took the stand in the pretrial, when this was litigated a little bit or argued on this motion about the card, bringing in the card from jail and showing that she didn't read a certain line. This detective was quite snarky, more than this, much snarkier. And I called it. I said she's going to have a softer approach during the trial because the jury's watching. And we get that softer approach, but it was this same chess game, just blatant in that pretrial hearing. It's fun to see it play out now again. Looking for questions here. If you have any questions, Matthew Harris in the chat. I have a shirt that says everything I learned about law I learned from Matthew Harris, Law PLLC.
Objection sustained.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people, such as Ms. Boone, or let me specifically. In the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
I confer, Judge.
Yes, sir.
See if he asked all the questions she wants asked. Didn't get the answers she wanted. It didn't have the effect that she wanted, but those were Sarah's questions.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State, any other witnesses, evidence, or testimony to be produced?
Your Honor, at this time, the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. And do not conduct any independent research or investigation as to the person, places, things, or charge involved in this case. And we'll bring you back in as promptly as possible. Thank you.
Jury exiting.
I love that the judge brings his law students right up there at his elbow. What a better way to view court. That's amazing.
Gotta do some legal things.
So
Bill may be seated. Thank you.
The state is done. Turn it over to defense. Little business here. Sarah, you're up.
Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break. If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you.
Okay, so one of the motions that the defense is going to file here, you can see, where's Sarah? Is she there? Oh, she's there. She was hiding. One of the motions that the defense is going to raise right now. Oh, she is smiley. Oh my goodness. What? Yeah, it's basically. Oh, Jules is calling in. Jules, hang on. I need this call to be on the other phone, please, please, please. Jules, hang on just 1 second, okay? I've got you on the wrong phone. The burner phone's not ported over to my new phone yet, so we'll try that now. Jules, can you hear me now? Jules, are you there? Hang on. I can't hear you yet. Testing 1, 2, Jules. There, we got you.
Okay.
What are you seeing in court today?
All right, so I moved.
Yeah. It was my fault.
Well, I moved. I'm over on the. Okay. I'm over on the defense side now, so this way I'm sitting directly behind. I'm in the first row, directly behind Sarah. I moved over there, so this when she's on the witness stand, I will get a very clear view of her, and I still have a clear view of the jury. I did ask Mr. Henderson before court started if I posed my question this way. Excuse me, Mr. Henderson, can you please tell me if you or Mr. Owens will be doing the direct when Sarah takes the stand? Because, there's speculation of a narrative as opposed to him asking. His answer to me was, Mr. Owens, here comes Mr. Owens right now, that Mr. Owens. So to me, she's not going to do narrative.
Okay.
Because I mean, wouldn't you take that like that?
We'll see. Mr. Owens, what's amazed me is these attorneys have followed Sarah's wishes extremely closely.
Right.
It would be safer to have an attorney guide you through the questions, just because, we've read Sarah's letters, and sometimes she can go off on different tangents and things. And that's always dangerous as a defendant, because it just opens doors everywhere. So it's safer, but at the same time, if Mr. Owens knows that she's going to lie, he basically has to go the narrative route.
Right.
So as long as he doesn't know she's going to lie, and she doesn't give false information on the stand, it's going to be better for him to question.
Exactly. And for all the naysayers out there, my reporting was spot on.
Yeah. Yep, you're doing a great job.
So there.
Let me ask you this. Sarah's been turning around, looking and smiling at someone. Is that directly behind you? Is there someone on her time? Does she have supporters who are there?
No, she has no one in the courtroom for her. The person that she is, the person that she is turning around to is Mr. Henderson's daughter. I forget her name, and then the blonde. I also forget her name. Of course, she has a nickname around the courtyard as what is it? Daenerys Targaryen. Take it as you will.
I'm not even sure what that reference is.
Okay, if you're a Game of Thrones fan, you'll know.
Oh, the blonde girl. She's the blonde girl from Game of Thrones.
Yes.
I haven't watched it. I'm sorry. I missed.
Okay.
I was busy watching Court back there.
Okay. Yeah, the buzz is that's the nickname she has been given. So in any case, that's who it is. No one else.
Okay.
No.
Well,
it's the only people that are in, and it is a full house today. It's all media from all walks, whether it's local news, YouTubers, print media, you name it, they're here. And Victims Advocate is here. But no, George's family, no one is here today.
Man, that is crazy. What are we looking like schedule-wise moving forward? I know Sarah Boone goes first. They've got an expert witness who's going to testify if Sarah can get them to that battered spouse syndrome level of defense for self-defense.
Then another expert, possibly a third expert, and depending on what Sarah says, there might be other witnesses that will be recalled. Because remember, Brian Boone is on subject to be recalled. Yeah. Mm-hmm.
As far as the other people you recognize there, I know we had Joel from STS. Is he staying there for the duration?
Yes, he is with. Yeah, we sit together. Mm-hmm. So if I get here first, I hold a seat for him, and vice versa. And what I can't tweet out, he tweets out. Like we're taking turns to get our live tweets out there as quickly and as accurately as we can. So we work well together. Awesome.
That is great. Who else have you seen there that you've shown up? Anybody you recognize?
No, not big ones. Like I really thought Peter from would be here, Peter Tragos, but I think he's not here.
He was scheduled for like the 28th, but we might be done by then.
Yeah, we might be done by then. But what do you call it? I mean, I could see why, because driving from the West Coast over, you have to take I-4, and it's just a horrible, it takes me 3 hours. So it would take Peter 3 hours as well. So, yeah. It is crazy. But no, I haven't seen, other than Joel, there's a guy, Sean, I don't remember his YouTube channel either. So
wonderful. Well, we're glad you're there. We appreciate it. Can you tell us a little about the jury before the break's over here? Today
they were paying more attention. Today they were more glances at Sarah where they have not been in the past. There was more note taking. So yeah, they seem, the jury seems more engaged today. I do not know if it's because they've got a sense that she's, well, now they know. Once the state rested, then, you know, they know she's taking the stand.
Yeah.
So, and they are starting, are they going in? No, not yet. There goes Mr. Owens. This man is so nice. You know, I know people don't like the defense team, but again, on a personal level, these men are very, very nice, and they are just doing their job. You know, that's the bottom line.
Honestly, they're doing a job nobody else wanted. I mean, 8 previous attorneys couldn't or wouldn't do what they've stepped up on short notice to do. Just as a professional, they deserve some credit for that. They're playing poker with a shorthand.
Sean, are we back on the record? I'm sorry. Okay. I just want to make sure that they weren't coming in. Yeah, so it is what it is, but people don't seem to understand that. I have a high regard for both teams, both sides.
Yeah, it's good lawyering, it's good work, and
is the judge back on the bench? Okay, thanks.
I don't see him yet, but I do see some activity. People walking into court. It looks like the lawyers are back. So
yeah, that's my favorite deputy.
Yep.
Yeah. All right. I will.
Thank you, Jules.
I'll talk to you later, guys. Have a great day. Bye-bye.
Bye. Jules, one of our reporters on scene. Appreciate her, and Chris, who's doing the technical work outside at the pedestal, the media pedestal. Thank you both. The last questions were ridiculous, Robin. Yes. What's going to happen next is the lawyers are going to make a motion, and they're going to ask the judge to make a ruling right now. They're saying, look, the state's just rested their case. Judge, you can call it right here. The jury doesn't need to do anything. You can just throw this thing out because the state did not prove their case. They didn't prove the elements of the charge. They didn't prove that it was my client. This is a ludicrous argument in this particular case. It seems like it's very dumb, but it is required because it preserves something for appeal. It will not be granted. It will not be granted. Because everything the state has presented that goes towards this second-degree charge that Sarah Boone is facing, if the prosecution presented the tiniest speck of evidence towards each element, the judge has to look at that in the light most favorable to the state. It's almost impossible to get the motion for directed verdict right now. It's not going to happen. Thank you, Matthew. You trained me well. I appreciate all the training you've given me. It's not going to happen, but it will be put on the record. And sometimes when it's this much of a long shot, it's very brief. You're not going to have a 10-minute oration listing all the reasons why this should be thrown out. It's going to be just for the record, make this motion and just hit the high points. We don't believe the state has met their burden, carried the burden, and for that reason we ask for a judgment. Yeah, not going to happen. Let's see. Ooh, oh my goodness, peekaboo. Another viewer inside court says that Torres families come in. Victims in the courtroom. As I'll just say, I mean, it's one thing to be in court. We know from yesterday that oftentimes we have family members very closely related to people connected in court that are watching us on the live stream. For that reason, I would just stress again that we don't say anything in chat that we wouldn't want said about our family members in public. Let's please be polite to everybody. Everyone deserves their day in court, even if we feel they're guilty or we think that the evidence is just overwhelming, condemning them. This is a right that you have in the United States to have a trial by jury, and is something that somebody exercising, even if it's a long shot, is something that I would defend to the end. I love that right. If they lose that right, then we all lose that right. So let's be kind to everybody, being aware that there are people watching that we don't know. that could be affected by what we say. Dallas born, Boston bred. Thank you for almost 2 years of excellent streaming. Dallas, thank you. Dallas born, appreciate you for the 20 months. OG. Is she testifying today? Allie B, yes. We expect her to be the first witness that the defense calls. So a couple motions here, maybe a little bit more housekeeping, and then we expect Sarah Boone to take the stand. The state did rest. Now they have lined up a lot of rebuttal witnesses. They have a really good idea of what they're going to hear from the defense, from Sarah Boone, from the defense experts, and they have their own experts to counter that. So those are lined up. There will be, as long as Sarah can get to that self-defense level, as long as that threshold is met, we're going to see quite a bit of rebuttal from the state. Just Teresa, just upgraded to a new courthouse. Congratulations. It looks yellow and beautiful. Thank you very much, Teresa. Thank you for being here. Wouldn't be the same without you here. Shannon Stevens, what if Sarah's defense is she just gets in the suitcase to show how easy it is to unzip herself out? The problem with that, the problem with her story is like, there was space. There was, 2 fingers. It was unzipped. I did it with 1 finger. The problem is we have a dead guy who wasn't able to. And no matter what you can do now or show, he wasn't able to, or he would have. And so, it being easy to unzip or left a gap so he could breathe or anything, it didn't work. And that's why we're here. Oh, Nicole says, I'm about to order my first Stevens hot cocoa. For those of you who don't know, winter is around the corner. Let me share this link with you just a little bit. Stevens hot cocoa is, it was my wife's favorite, has become my favorite. Not a sponsor, but I have to say that if I send you a link, this would be an affiliate link. So I think that if you were to order something, Amazon might give me a couple pennies out of their profit from the order. But my house is fully stocked with Stevens hot cocoa. And I recommend starting with the basic because you cannot get much better. Why did it not work? My computer is going very, very slowly. I think I just added a pizza to my Amazon Prime, and I don't know how I did that. I'm not on a pizza page. Anyway, apparently I can't show you what that is, but Stevens hot cocoa is delicious. I recommend the milk chocolate one, Nicole, and you'll love it. It'll change your life. It's sort of like spicy maple bourbon pickles from Walmart, which will also change your life, but in a different way. Also not a sponsor. All right. This is Adam, by the way, this Recovery Addict gentleman. This is Adam. He's a longtime supporter of the channel. And he always changes his name to be something that's sort of pertinent to whatever's happening in court at the moment. And yesterday, we were called out very specifically. And the lady who called us out called us Court TV with the guy with the headphones who talks in the corner and does commentary. And so he changed his name to be, instead of Recovery Addict, he changed it to Court TV Very Addict. And I love it. Tish, one of our great mods, thank you for gifting 5 memberships, Tish. Good luck with training your new employees today. I saw that was going on. It's exciting. So after Sarah testifies, can the state put forward a motion to say it doesn't reach BSS level? I think they can. Secret Smiler. This is going to be, because I think they'll put some effort into this as well. Her story has to be so good on that level that it meets the threshold. Because if it's not, it's going to be challenged. And if they can challenge it, it basically gets rid of everything else the defense has. If they challenge it and win, it gets rid of everything else the defense has. And And so I think they'll be listening very closely to see if her testimony meets the threshold. Either way, the prosecution wins, because if her testimony does meet the threshold, it's because she told a very different story from any others she's told anybody else thus far. So they can cross her and impeach her on her testimony using her previous testimonies. If it doesn't reach that threshold, they win because she can't use that self-defense claim with battered spouse. Legally Blonde, thank you very much. Also gifted 5 memberships. Chris Wallace, thank you for gifting a membership, making people feel welcome here. Looks like the judge is coming back to the bench right now. New law assistant, student, next to him there.
We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure, on behalf of the state. William J. for the state.
Defense.
James Owens for Miss Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach the podium, Your Honor.
Yes, sir.
Your Honor, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want
just
to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially has assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry?
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are 3 elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony, an argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is a prima facie case that in fact she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law.
Denied in 3.
Thank you. Response.
Yes, thank you.
It's going to be denied. It was a good try.
Standard at this time is just a prima facie case. Whether any trier of fact, in taking all the facts in the light most favorable to the state and the inferences drawn from them, establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Miss Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m. 45 seconds should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events, and therefore we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement both on the 24th and 25th that I have no idea what happened. I just went to sleep, everything was good, and then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
Thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Okay. Ms. Boone, I have a couple of questions to go over with you.
Welcome, Ms. Chris.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last. Call whatever witnesses, put on exhibits, the photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, for the court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal. To just go through it again, because I know you're going to ask the colloquy about all that. So I'm going to need a few moments with her. I don't know if it's 10 minutes maybe for the 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity. But before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can... Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
All right. So that, I don't know why Mr. Owens presented this like it was a surprise. Like they had bet everything on that judgment of acquittal. And he didn't. That's not true. But I think he does. I think it's wise for him to say, I want one last conversation with Sarah. So this will be her call. Rob Lawn Lumber, welcome. This judge is amazing. Absolutely. We love him. We're going to export him or clone him to a lot of other courts. He's really good. So she's going to get transported out with her attorneys, probably have a bailiff nearby. If they're in a private room, then the bailiff's not going to be in there with them. But one last discussion. What does he say? Could be, are you sure you want to do this? You know, I mean, the time to be frank is now. To put on the table, look, this is what's coming. You've said battered spouse. We've followed what you wanted to this point. This is the next step. Are you ready? Try to stay focused. Maybe a little refresher on as far as keep your answers simple. As close to what we've practiced as possible, gone over as possible. But this is the big show now, and every word she utters is going to be listened to in very close detail by the prosecution and be compared to her previous stories. Can she come back and take a plea? I've heard, Kimbers, and I don't have this from official, from the prosecution, but I've heard that the deal was on the table up until verdict. I doubt that we've gone this far just for her to take a plea deal. What sort of narcissist would that be to carry on this process that
Call
long?
from.
My volume's down.
Donnie, thanks for turning your volume down. What's up, my friend?
Have you ever reached out, or have maybe your team reach out to Martha with the missing,
No.
what?
I'll have to tell you, the Martha stuff that we talked about on Ian's channel last night that broke in the other case. My personal belief is we never insert ourselves into court. We've been dragged into court a couple times. It's the third case that.
I know a YouTuber that did that though. They get involved to the point where they're talking, to whoever did something in the room. That you have your own thing going on, but she's also 84, and she probably has no idea what's going on.
I'm excited that we're involved in a little bit, but I have too much respect for the judicial system to insert myself.
I don't know how you thought maybe in the beginning you were going to get in trouble of any kind. You can't get in trouble. First of all, it's your job. It's what you do. and you can't monitor the whole world on who watches you and why.
We didn't do anything wrong. It was fine. And I don't think Martha did anything wrong by watching our channel. What we said.
Is her name Martha?
Martha Jane. Yeah.
Oh, it is Martha.
Yeah.
Oh, I thought I was thinking a totally different name. I lucked out. Okay. Yeah, it's just me again. That's it.
All right. Thanks, Donnie. Bye. Yeah. After court's over, I'd be willing to talk to individuals, but during a trial, let the process play out. There's lawyers there for a reason. Don't be involved. Don't be involved. I've told you this. I've turned down phone calls from a defendant during trial. Tucker, the Treehouse trial. Literally, my phone rang with his number. I knew it was his. I knew what it was. He wanted to talk, and I wouldn't do that. Sure, it would have been great for YouTube, but the justice process, the access we have as media, is so important not to burn that bridge. It only takes one intrusion where ripples are formed that can hurt the entire process, not just for me but for everybody, and won't do that. All right, quick break. The lawyers are out on a quick little last minute discussion with Sarah Boone. And then she's going to take the stand. She's the first witness up. The reason they have to put her first, and you heard Mr. Owen say, I usually have my defendant go last. If we're going to put him on the stand, they're usually the last person. In this case, because of the pretrial rulings, specifically regarding self-defense, the claim of self-defense, because none of the evidence so far has met the standard that would shift that burden onto the state, they haven't been able to really say anything about it, and they can't in their case until that standard is met. So Sarah has to get on the stand and tell her story. What does that mean? It means she has to talk about instances of abuse, that she was in fear for her life, that it's going to bring up a lot of past domestic violence situations with George, and unfortunately there were a lot, and they went both ways. I think both of them served time. Some days in jail regarding domestic issues. This was not a smooth relationship by any means. She has to bring that up and meet that threshold for the self-defense, because this is a shifting of burdens, right? Right now, the burden is on the state to prove that she committed the crime. Well, she did it. They've pretty much proved that part as far as who done it. But now she says, but I have a defense. It's a self-defense because of a battered spouse. Once she meets that threshold, the burden shifts back to the state to prove that it wasn't self-defense. But we'll see. I think she's going to be able to meet that burden, even if she has to tell a completely new story.
Call from Fractured 23.
Fractured 23, how are you doing? We're almost done with the break, I think, but we've got a couple minutes.
Not too bad. I just had a thought. I'm not sure if anyone else, everybody's probably thought of this because we've been doing it a while. But so in her interview that they showed yesterday, she was talking about how they had like this great time and, nothing had happened in a while and he was doing so well and blah, blah, blah. Doesn't that completely like defeat her battered spouse? She was in fear for her life because she said in the interview she wasn't. There was nothing going on.
The only thing she said in her interview that she was afraid of was his family when they find out what happened. So yes, that's going to be used to impeach her testimony. That's going to be brought up. Her previous statements by the prosecution, they're going to be like, Sarah, what do we believe? Do we believe Sarah at the day of the crime? Do we believe Sarah in the interrogation? Do we believe Sarah at the hearing we had 2 weeks ago? Do we believe Sarah today? Because all of them are different, and not all of them can't be true. So she's going to be impeached one way or another.
Yeah, because I was like, I rewatched yesterday, like her testimony when they brought up the whole like thing. I was, but wait a minute, during that interview, like they questioned her extensively if there was any violence on the day that he died, and she was adamant there wasn't. So what was she afraid of in that moment? Like there was nothing going on. She even said there hadn't been anything recently.
Yeah.
So like she doesn't make any sense.
Yeah, they were doing puzzles.
Literally
they were doing games,
nailing
they
her
were
own
listening
coffin.
to music. It was a great day. There are no marks on me. We haven't had a fight. It's all
Right.
that is going to stand against what she's about to testify to. But that defense, that battered spouse defense, it may have room. It may have room for her version of events to give her some coverage, and it's going to be a stretch if it does. But
right.
let's see
And
how the story is told and what she presents and what the jury believes.
Right, and I don't want to, like, just so people are aware. I'm not ever saying, like, people lie. Oh, I see they're coming back. But like, it just because I've been in abusive relationships and I understand how that goes and stuff. But it just I'm excited to see how it goes, and I'm so glad I get to watch it with you guys. You have the best channel, best chat. Love y'all.
Fraction, thank you very much. Good talking to you. We'll see you.
Okay.
Bye.
Bye.
All right, Sarah comes back with her attorneys. They've obviously had their discussion. There might be a little colloquy here with the judge as well. Original Sin, congratulations. Thanks for the 13 membership month anniversary. I'm surprised still every time I see Sarah about how giddy happy she is at being here. And I realize she's been in jail for a long time. She's wanted her day in court for a long time. And I'm happy for that. I hate hearing about people who sit in jail waiting for their day in court. If you're not convicted, jail is not the place to be long term. But so I'm happy that way. But her level of just glee that she's exhibiting seems wrong. Bailiff. Not sure what they're talking about. This is the Sarah show now. This is her time. If she testifies in the narrative, which we don't think she will right now, Matthew Harris, OG. Thank you, my friend. Glad to hear you're busy in court, but man, we miss you when you have real work to do. Thanks for being back today. Appreciate you. If she testifies in the narrative, it's a train wreck. It's everything we've read in all of her letters coming back again. It's the complaints about how many days in court, how many birthdays she's missed. It will go everywhere. About the judges, she'll probably go all the way back to speedy trial being waived by her attorney, and how she's upset about that. Obviously, the Detective Kielspel, I can never say her name right, being tricked by the detectives to come down to the police station where she thought she was just getting her phone. All those parts will come in. But if Mr. Owens can ask the right questions and Sarah can keep the answers specific, we might get through this surprisingly fast. Surprisingly fast. Just Copsel. Thank you, 1776 daughter. Detective Copsel. I should remember that, like cop, but I can't. Names are terrible with me, or I'm terrible with names. She'll spill the tea on all her previous attorneys. Can you imagine if she opens the door to that? Because I know if defense opens the door, prosecution sort of has room to go there. And she's said, I don't want that brought up, but she might bring it up herself. And that would be eye-opening. That would be a fun little moment. I'm sure objections would fly. Lisa, we've heard that the Torres family is present, or at least members of the family are present. If that's so, I'm sure they'll be watching closely as she testifies. And we might... Sadly, that's generally the people that you get reactions from during court, that the judge has to make sure he cracks down on. Do you think if this judge has been on the case from the beginning, would this have been done a long time ago? Oh, man. I think what we're seeing from this judge is how he is in all his cases. So... yes, I I believe possibly some rulings would be a little different. But it would have sped things up a little bit. I think he would have cracked down on the letters from her and probably handled that a little differently. But really, what can you do? It's it's communication to the judge. It has to be revealed to both parties. So it has to be made public. That's Florida, Sunshine State. That's how they do things. I don't know. It probably would have been the same, but I think it would have been faster. Obviously, changing attorneys was the big delay over and over and over. My new favorite judge. Virginia, we think that his family is in the courtroom. Which members? I'm not sure. Does Florida have the rule that victims of a crime are exempt from the sequestration rule? Because I know at least her brother was told that he was going to be, kept on the witness list. He was not released fully, and that normally would exclude you from being in court. Maybe it's other members of the family. On prosecution, what are the chances that on the cross that the prosecutor holds up the suitcase in front of Sarah? Do you think that image is going to play itself out? Do we need to start a page? Rate this judge? We've seen so many good judges. Okay, now we're just waiting for the judge to come in. It's her confidence that's making her smile. I'm not sure if there's going to be additional colloquy or if those brief questions he asked before the break were enough that the defense can just proceed with their case. It seems like he's more verbose in his official duties than what we got just before the break. Once again, I'm going to give a shout out to Trial TV Live, who are participating, helping us get this feed live from the courtroom in Orlando. And it looks beautiful. Looks beautiful. We will put the not intentional counter back on the screen when Sarah's testifying. We also counted up to 57 times it was mentioned either by her or by the investigators during her interrogation video. So as far as counters go, we have the bless you counter at 14. And if I can switch this quickly, I'll show you the other. And the not intentional counter is at 57. So we'll start with this one. I owe you a mug. Don't. What was our bet, Adam? What was our bet? I bet that she was going to testify, that she was going to take the stand. I need video proof of that bet, so we can hold the other person accountable. It might be me. Dallas born, Boston bred, gifted a membership. Thank you very much, Dallas. Once again. I know Peter from Lawyer, they got hit with Milton. I think they were safe. Everyone in the family was safe, but they're still doing hurricane cleanup. For those that aren't in this area, that storm was insane. Milton was wild. Helene, before that, crazy. I helped with Hurricane Helene cleanup. I think I said Milton before, but over the weekend, we did Hurricane Helene cleanup down in South Carolina. And unbelievable, the size of the trees that came down. I mean, you can hide a car behind the trunk of the tree. And having those come down, power lines, all new poles put up, new power lines, houses just smashed. I have to show you a picture. I was cutting one tree back. It had fallen. It was a huge tree. It had fallen from one property across another and into a little brand new subdivision under construction. And we're cutting branches and cutting. We found a Hummer underneath the tree. We didn't even know it was there when we started cutting. We found an awesome, nice black Hummer under there. But Nurse for God, thank you, my friend. Another longtime supporter, generous supporter of the channel. 5 gifted memberships. I don't know if it's a H1 or H2. I could only see the front. We couldn't get to the back. There was a broken building that had been smashed into the Hummer, and the tree was on top of the building and the Hummer. But it's fun. The soreness of my arms from running a chainsaw is finally dissipating. But I cannot wait to get a new chainsaw. I got to use some good ones, and now I know what I want. Nurse for God, glad we can help you out. Be entertained at work here. This is a long break. The judge said he was going to remain in court during the break, but he didn't. So now we're left to wonder what's happening. We check with some of our reporters there in the courtroom. The first property we went and cleaned up at, professionals had already come and removed the tree off the house. But imagine looking at like the up house. This house looked like the up house, that sort of steep pitched roof and everything. But the tree had come from the back and fallen towards the front of the house. And the whole top layer of the house had shifted about 5 feet forward and then crushed down. So like it just severed that upper layer and pushed it down. And then we did the cleanup of all the smaller trees in that one because it was wild.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state. William J. for the state.
Defense?
James Owens from Miss Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering in the affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarification, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay. All right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as
Whoa.
it relates to her right to remain silent or testify, I have nothing about that.
Okay. Then what do we need to address with regard to Holland?
Holland.
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at the bag.
What?
And the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one,
The overt act is going to get them.
of course, I've got a lot of photographs about the prior violence that George Torres committed on Sarah Boone, and there's a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence or she took action to either block or physically restrain George Torres from committing an act of violence on her. But, Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that George Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by George Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020 before we go into reputation evidence, prior instances of violence, or matters of syndrome evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
Really?
I'm confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she She had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence.
Any particular reason why it hasn't been done in the last 45 minutes?
Because
I sent my jury out.
I've been meeting with my client about her rights to testify or not, and other related matters. So, in terms of not giving her this evidence,
in terms of anything that the state just discussed,
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase, which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon. It's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies, and I have not had a chance to view that evidence other than seeing it here today, but I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
Judge is not happy. He seems very calm, cool, and collected, but he has not put up with any delay, and I think he has to sort of grant this one. Early lunch, maybe. There's the actor from Game of Thrones coming and sitting next to Sarah Boone. I see the resemblance now. They want to physically play with the bat and the suitcase. They're going to glove up and pick him up. Can you imagine what the bailiffs are doing? Okay, the bailiffs are like, hey, whoa. Because technically the bat is a murder weapon, right? It's a weapon used in the crime. They're like, can we not have her hold it? Owens, can you be at bat and have Sarah be catcher in the suitcase instead of having Sarah be at bat and you be the suitcase? Yeah, don't give her a weapon in the courtroom. Especially one that it's not like there's a safety you can put on the bat, right? You can't put a gun lock, a trigger lock on the bat and call it safe. You can wrap it in foam. Can we get like a plastic, like a wiffle bat that can be used as demonstration instead? They're asking to look at this case clearly. Reading the tea leaves here about what's about to come. It sounds like Sarah's testimony is once again going to stress how easy it was to unzip the suitcase and how it was reasonable for her to assume that George could have unzipped the suitcase. We hope that this time when we hear the testimony, we actually see her hand motions, which we don't have before. When he said his head was here and the hole was here, we don't know exactly how that orientation was lined up. But we hope this time we get a better explanation so it's a clear understanding for us. If the hole was behind his head, unzipping that and getting his arms up through the suitcase and around, yeah, that's not going to be possible. If the hole was right in front of him, it would have been maybe more plausible. But I would love to see Sarah, throw the gloves on and show with one finger how she can just unzip the suitcase. Of course, you'll need some weight in the suitcase or else it just gets pushed around. Ooh, first time we get a look in court. There is Jules right there in the red and the black, the checker. Joel right by her side from STS. Let me see who else we've got here. trying to recognize some faces. Gentleman in the far corner over there has been following trials since Casey Anthony, also a YouTuber. Room is packed. Jennifer, I don't know if the judge has to allow this. I think he sort of needs to, because it's the amount of delay it causes in the court is very small. Okay, 15 minutes of delay or taking an early lunch, it's not a lot. And this attorney basically can have an argument saying, hey, we weren't even allowed to look at the evidence. Since I came on, I haven't been allowed to look at the evidence. This physical copy. Sarah Boone was allowed to. She asked to have what's called a view of all the evidence. All that was brought in, and she went there with, I believe, her investigator, Billy Lane from Prison Break Investigations. They went there and looked at it, but they might not have done the zipper test. You know, how easy is it to unzip? If she gets up there when they're looking at the zipper test and sees that the zipper just does not open, and it takes some force, and you have to have a paper clip attached to it to make it work, you can bet that the other people who are going to be watching and paying close attention are going to be the prosecution. And they're going to come and say, now, did you have a chance to look at that suitcase today? Did you try to unzip it with your... Can you demonstrate with us how with one finger you can unzip this suitcase? Yeah, it's going to be epic moments here. Loretta, isn't it a significant gamble for the prosecution given what happened with the glove in the OJ case? I don't think so. The glove in the OJ case, the evidence was a little bit different. They didn't have a video of the crime in progress with the defendant's voice in the background narrating the occurrences like they have here. So I would say that the prosecution has a slam dunk case, and there's nothing that the defense is going to prove with one of the items of, you know, it's not the glove doesn't fit type scenario. Well, clearly the bat doesn't fit in my hands. No, that's not going to work either. She's already admitted to everything. Couldn't they tamper with the zipper? Everyone's going to be there. Prosecution will be watching, defense will be there, and bailiffs will be there. Bailiffs are there sort of overlooking the evidence itself. Prosecution will be there, defense will be there. And so anything that happens, they'll be like, hey, we were there. We watched you just rip the zipper. You damage the evidence. It'll happen in well, not necessarily public view, but it's possible the cameras could even be on for that. Is Billy Lane in the courtroom? I believe he was previously in trial. I'm not sure if he's been here every day. We'll have to ask Jules. She shouldn't be allowed to mess with the zipper until she's on the stand testifying. I think if the judge holds them to that, because yes, if this is brought up on the stand, this is something you can do. Prosecution can say, hey, come on down. Can you demonstrate with this suitcase what you said you did with one finger? That's perfectly acceptable. But the defense saying, I want to spend some time messing with the suitcase and the bat first, they don't know. He doesn't know. He's not confident that Sarah can really unzip it with just one finger. And if she can, I guess Samsonite zippers are amazing. Most suitcases, not so much, especially with somebody packed inside like it looked like someone was in the video. Yes, and it was actually George. If the zipper unzips, you must acquit. Lisa, welcome. You're coming in right at the right moment, Lisa. Sarah Boone is about to take the stand either right now or we're going to take a lunch and she'll come back right after lunch. But she's going to be the first witness. The state has rested their case. Defense is now taking over. The judge had a colloquy with Sarah, asked her all the questions. She answered the questions correctly with following my prompts. No, just kidding. I just put the signs up for what was right and wrong. But they answered all the questions correctly, so the judge will proceed. Sarah's happy with her lawyers. She's in on this. Her decision to testify, she's sticking with that so far. She's okay with the way the lawyers have presented their case. She's on board with everything. We're ready for her testimony at this point. Although she still could change her mind if she so chooses. right up to the point where they call her on the stand and put her under oath. They can do that.
It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits, and along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand by. Bring back in our panel.
You will bring the jury.
Let's hear what time the judge says we're going to be back at.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Yes. I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exiting.
As the jury heads out for lunch, we're going to take a lunch break as well. Let's see if they show us some of this evidence view. We have had a lot of breaks today, and the judge is not going to put up with much more.
Y'all may be seated. Thank you. State and the defense, if you could please review those items, and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
Okay, state and defense. Can we please review there's They're saying, don't take Sarah away. Now, this is interesting. Most courts have a rule that when the judge is off the bench, the defendant has to leave. So they sort of have to violate these rules. And I'm not sure if the officers there, the bailiffs there, have the authority to do that. So they might be working out that issue right now. Judge has 3 students up there with him. Shaking hands. Happy to be here. All right, it looks like we're not going to get to see the... we'll see heads move as they walk back and forth. But it looks like we won't get to see the evidence view. What we'll be telling is when she actually testifies, if she changes her story and doesn't put much emphasis at all on the one finger to unzip. It's probably because she wasn't able to unzip it with one finger. But can they show this? They can. As a matter of fact, Michelle, if you go back to the pre-trial hearing when Sarah Boone was pro se and she asked for an evidence view, she said, I want to see all the evidence. I don't have it all. The judge set up an occasion where they said, we're going to do it. It's going to be in court. We're going to bring it all and you can watch and cameras will be here and everything. And Sarah's like, I don't want that. Okay, I don't want the cameras there for this. And the prosecution actually said it was actually more convenient if we hold this at the sheriff's office. They tried to keep that secret that it was at the sheriff's office, but they actually let it slip during the hearing. So at the sheriff's office, they met, and it was in a private area, so the cameras could not be there. Normally, this evidence view would be open to the public. If she gets in the suitcase, oh my goodness, I'm going to lose it. There's no way she's going to reenact to that. That doesn't help anyone. At least not on the defense side. Get your goat ready to scream. My goat is ready. I have both goats. We have the standard issue. And we have the louder Christmas edition issue that are both ready for extensive use today. Quick recap, Kaylee. We have heard the end of Detective Copsell. Copsell. There it is. Second try. Her testimony. She was the detective, the female detective who participated in the interrogation of Sarah Boone. That video recording we watched all day yesterday, or all afternoon yesterday. The detective on cross-examination held her own, where the defense Mr. Cacciatore tried to trip her up a little bit on her report, tried to get her to refresh her recollection. She answered in a way that she never had to refresh her recollection. And that was a little frustrating to the defense. You could tell because he kept saying thank you to her, meaning something other you instead of thank you. She beat him at that game, at that chess game. It's not that it mattered much, but it would have been nice for defense to be able to say, yeah, we corrected your investigator on this issue. They testified wrong at court. They couldn't remember. That's a little win for them. They didn't get any of those. Yeah, bless you. Bless you was what I was thinking. Bless you instead of thank you. Right. But what we know is that Sarah's going to be the first witness up after lunch at 1 o'clock when we come back in about an hour. Well, we'll come back in an hour. Sarah's going to be up. She's going to be on the stand. The motion that was made, or sort of like the issue that was raised with the judge, it wasn't really a motion because this issue was sorted before in a pretrial motion, that based on the Holland case law in Florida, there has to be an overt act that day for the self-defense battered spouse situation. There has to be something that George did, some sort of threat, some sort of occurrence that happened that made her fear for her life and act in the way she did, using either non-lethal or lethal force to restrain or prevent her from being injured. She has to testify that something happened. Here's the problem. Her previous testimony is that nothing happened, that everything was good. We sat on the back porch, we smoked, we drank some wine, we did some puzzles, we listened to some music, we played some games, everything was fine. Now she has to say something different.
Call from Jules.
Jules, I got a lunch break delay.
Oh boy, you guys have no clue.
What's happening?
I got to see the freaking suitcase up close and personal, and I got to see Mr. J. I totally flip out.
Is he mad that they get to touch the suitcase?
Yes, and not only that, though, Mr. J was asking, Mr. Owens was asking for the paperwork and the stuff that was left in this suitcase, and Mr. J didn't want to answer the question. Now, this is all outside the presence of the jury, and of the judge. And I don't know if the camera was still going or not. A few people saw it, but Mr. J literally picked up the box and turned it upside down and shook it and said, "There's your evidence right there," and then threw the box down.
Whoa.
Crazy. And
I've told you this is personal for him for some reason. And
it really is.
Wow.
It was bad. It was bad. It was like so bad, Scott. What do you call it? And Sarah was right there. She had her gloves on, and it was bad.
They want to test the zipper, right? They want to make sure that she can unzip it with one finger. That's very important. The easier that zipper unzips, the better it is for the defense. So a can of WD-40 slipped in would be like excellent about right now. That zipper needs to flow like butter.
Yes, but there is a heavy presence of security once it was established that she was taking the stand. We've only always had just 3 deputies, and now we have 6. So,
We've heard there might be some of Mr. Torres's family, George Torres's family, in the audience.
Not yet.
Okay.
Believe me, I've been with the victim's advocate on this. Chris, can you turn my car on, please, so I could get some air? I'm on doing a live.
Tell Chris thank you. He's doing a great job.
There was that, and I never saw him so. Mr. J has had attitude, but this was bad. So, did they have it on camera?
No. We cut away to the state seal when the judge was just leaving the bench, so we didn't see anything that happened after that.
My God, you have no idea. Me and Joel from Surviving the Survivor, we were like, I grabbed his arm, he looked at me, and I'm like, everything was fine when they were presenting the photographs, okay, and examining the suitcase. But when that exchange took place between Mr. J and Mr. Owens and him, he was terrible. And so it wasn't just me, it was everybody went, and it was audible. Because it came out of nowhere. We didn't expect that flash of temper out of him. And so
he's upset because he lost.
The deputies.
He objected to the defense being able to touch any of the evidence now.
I know. But here's the thing. The judge, Mr. Owens said, like, maybe Sarah had a chance to, but I only came on the case, afterwards. I didn't get to inspect it. So the judge did side with Mr. Owens. And I think the reason why the judge is siding with Mr. Owens is because he is trying to keep the record as clean and clear as possible. But after that outburst by Mr. J with the suitcase and stuff, Mr. J instructed the deputies to tell us to leave the courtroom, that it was only the client and the defendant and the attorneys were allowed to stay. I called BS on that. You see, I'm minding my language. We, as the media, are allowed to watch that. but because he had an outburst and we all saw it, the only thing I could think of is, now that I know, I thought Court TV was filming that, but now I know that they weren't. But he must have thought they caught my outburst on camera, and now he wants us out.
Yep. Well, it was observed, and it's you're absolutely right. The original evidence view that Sarah Boone had negotiated for when she was pro se was going to be in the public. It was going to be in the courtroom, and media. The judge says media is allowed. Courtroom is open. So
we got thrown out.
The prosecutor is, I would say, absolutely wrong on this one, and that's also not his call.
It was his call, though. He made it. He said to the deputies, I want everybody out. I mean, no, what they should have done was brought the judge in and said, Scott, I believe it was because he was caught in a fit of anger.
Yeah.
And he wanted us out.
Well, there goes our chance to interview him after the case. But
I'm still gonna reach out to Mr. J, but I know I can score with Mr. Owens and Mr. Henderson. I know for sure. I was gonna try with Mr. J, but I'm so mad at him right now. But in any case, that's.
Jules,
oh my God!
Thank you very much.
I can't believe they didn't show it. You're very welcome.
That's
All
why
right,
we have
bye.
you as a reporter there. Thanks. Have a great lunch. We'll see you.
You too. Bye-bye.
Bye.
Call from Beauty.
Beauty, this is RA. How are you doing?
Hey, how are you?
I'm doing fabulous.
Good. Long-time watcher here. First call in.
Yeah.
I live in St. Petersburg, about 90 minutes away from Orlando, and I wanted to find out if it's worth trying to get into the courthouse.
It's going to be tough. Now that Sarah Boone's testifying, there might be a line. Media presence is massive today. It's sort of been building to this point. This is sort of like the pinnacle.
Yeah.
The only thing that's going to be more people there is for the verdict. So
yeah, I was wondering though, not necessarily the day she's testifying. Obviously, I would head over there real early one day this week.
I'll tell you, our team gets there about 5:45 in the morning. To get space to get in, and there's lines, so it's going to be tough to get in. I think everyone should go and watch court. I think it's a great experience. It's different in person than watching it on a TV or on a screen, but I can't promise you'd be able to get access.
Yeah. Do you know how many people are allowed in aside from media?
I think it's just a space issue, and I don't know if they're reserving media space versus public space. It's all sort of first come, first serve, and the media gets there really early.
Well, they're doing a great job with coverage, so I just, Orlando traffic is a nightmare from here anyway, so I was just trying to weigh out my options.
Well, you'll probably have a couple days, and I'd say tomorrow might be an easier day to get in than today for sure. But the closer we get to the end of the case, people want to be there for the verdict. So
awesome. Well, I can't thank you enough for everything you continue to do with the Carolinas and everything. Being here in Florida, we got hit too. So you're a good man. And I appreciate you so much.
Thank you. Thanks for the call. Good talking to you. We'll see you.
You too. Have a great day.
Bye.
Bye.
All right, we are going to take a lunch so everyone can get a break while everyone else in court is getting a break. So we will be back in just a few minutes. I know I've got people calling. I've already started the music. I think this is Mathis. I'm sorry, Mathis. From Germany. He's calling from Germany. After the break. We'll be back. The first person we expect to see on the stands when we return is Sarah Boone. There may be some discussion because of that little outburst. Once the judge is back, the defense might say, I just want you to know this is what happened. And unfortunately, defense won't be mad on our behalf for them kicking us out of the courtroom. I wish there was someone there that could represent us. That's the media side, but we are not a party to the case. Filing a motion, that's not a party. It's a little bit tricky. You have to be a lawyer, all sorts of things. So we won't get represented there, sadly. But the judge might hear about what happened as soon as he stepped outside the door. can't wait for that. I'm excited. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 45 minutes. We have a portal set up already, so if you want to continue discussing what's happening this morning, I'll portal you all over. The same folks will be there. We'll have this same stream going. Actually, I'm going to keep the stream open. I'm going to close this one and open the next one, so we'll have anything that happens in court, you'll be able to watch it. I'll do my intro when I finish my lunch, so we'll just do probably like 2 minutes of downtime, then we'll be back up with the stream, if that works. So we'll have everything for you that way. You guys, we'll see you in a little bit. Bye-bye.